The billing alert appeared at 11:47 p.m. on a Tuesday, flagging 17 unauthorized access attempts to my client files. I stared at the notification on my laptop screen, the blue glow casting shadows across my home office. Fitzgerald Friedman, 42, professional development manager at our startup legal hub in Boulder. 20 years practicing corporate law had taught me to trust my instincts. This felt wrong. The case management system showed someone had accessed the Meridian Industries merger files multiple times, between midnight and 3 a.m. over the past week. The timestamps made no sense. Our office locked down at 9 p.m. Security badges tracked every entry and exit. I pulled up the access logs. The user ID belonged to Ethan Montgomery, my co-counsel on the Meridian deal. We'd worked together for 3 years. Built a reputation handling complex corporate transactions. The partnership trusted us with their biggest clients. But Ethan had been in Denver all week. Depositions for another case. I'd covered his court appearances myself. The system showed him accessing billing records, client communications, and settlement negotiations. Files he had no reason to review. The Meridian deal was my case. My client relationship. My billable hours. I scrolled through the activity log. 17 separate sessions, each lasting exactly 43 minutes. Someone had been methodical, careful. They knew our systems well enough to avoid triggering automatic security protocols. My phone buzzed. Text message from an unknown number. Check your email, now. The message contained a single attachment, a PDF of internal memos. My name appeared in every document. Billing irregularities, client complaints, missed deadlines, all dated within the past month. All cases I'd handled flawlessly. The memos painted a picture of professional incompetence, systematic failures, ethical violations that could destroy my career, but I'd never seen these documents before. They weren't in our official files. Someone had created a parallel narrative, a false record of my work, and they'd used Ethan's access credentials to build it. I checked the metadata on the PDF, created yesterday at 2:17 a.m., the same timestamp as one of Ethan's mysterious system logins. My hands trembled as I reached for my phone. The partnership meeting was scheduled for Thursday morning, 2 days away. If these fabricated memos surfaced during that meeting, my career would be over before I could defend myself. The billing system chimed again. Another alert. This time showing a $47,000 discrepancy in the Meridian account. Money that should have been in our client trust fund. Money that was simply gone. The partnership had always been my sanctuary. 3 years ago, when I'd left Big Law to join this Boulder startup, Ethan Montgomery had been my guide through the transition. He'd shown me the coffee machine on my first day, introduced me to the managing partners, helped me understand the firm's culture of collaboration over competition. "We're building something different here," he'd said that first week. "No backstabbing, no billable hour wars, just good lawyers doing good work." I'd believed him. We'd built our practice together. Corporate transactions, merger negotiations, securities compliance. Our clients trusted the Montgomery Friedman team. We'd closed deals worth over $200 million in the past 18 months. Ethan had helped me navigate the politics of our management committee. When senior partners questioned my billing rates, he'd vouched for my work quality. When I'd struggled with the firm's case management software, he'd spent hours teaching me the shortcuts. But now, staring at the fabricated memos on my screen, I realized how perfectly positioned he'd been to destroy me. I started with the basics. Our case management system logged every action, every document access, every billing entry. If Ethan had been building a case against me, there would be digital fingerprints. The Meridian deal files showed the pattern clearly. Over the past 6 weeks, someone had been accessing my work product during off hours, copying client communications, downloading billing records. The access logs showed Ethan's credentials, but the timing was wrong. He'd been traveling extensively. Court appearances in Denver. Client meetings in Phoenix. I pulled his travel receipts from our expense system. Hotel charges in Denver on the same nights his user ID was active in Boulder. Either Ethan had mastered by location, or someone else was using his login credentials. The billing discrepancies were more sophisticated, small amounts at first. $500 here, $1,200 there. Charges that could be explained as administrative errors. But the pattern was clear when viewed together. Money was being systematically diverted from client trust accounts. The Meridian account showed the largest theft. $47,000 missing from a settlement fund that should have been untouchable. The money had been transferred to an operating account, then immediately withdrawn as a, quote, consulting fee to a company called Alpine Legal Services. I'd never heard of Alpine Legal Services. A quick search showed it was incorporated in Delaware 3 months ago. No website, no business address. Just a registered agent and a corporate filing fee. My phone rang. Serafina Chen from our IT department. Fitzgerald, I'm seeing some unusual activity on your case files. Multiple access attempts from different IP addresses. Have you been working remotely this week? No, all my work has been from the office. What kind of access attempts? Someone's been trying to log in using your credentials. Failed attempts, but they're getting close. I'm going to reset your password and enable two-factor authentication. Serafina, I need you to pull the access logs for Ethan Montgomery's account, going back 8 weeks. Can you do that quietly? A pause. That's a sensitive request. Is there a security concern? Yes, but I need to verify something before I escalate this. I'll have the logs ready in an hour. Meet me in conference room C. The access logs told the complete story. Ethan's credentials had been used to access my files 127 times over the past 2 months. Always during hours when he was documented to be elsewhere. The IP addresses traced back to a coffee shop 6 blocks from our office. Someone had been conducting surveillance on my practice, building a comprehensive file of my work, my clients, my billing patterns. They'd used that information to create the fabricated memos, to steal money from client accounts, to position me as the fall guy for their own crimes. But the real revelation came in the metadata of the forged documents. The creation software was Adobe Acrobat Pro, licensed to our firm. But the license key belonged to a computer that wasn't in our inventory. Someone had installed our software on an external machine. I traced the license activation to a laptop purchased by Alpine Legal Services, the same shell company that had received the stolen client funds. The pieces assembled themselves into a clear picture. Someone inside our firm had created a parallel operation. They'd been stealing client money, forging documents, and preparing to blame me for their crimes. The partnership meeting on Thursday wasn't just a routine review, it was going to be my execution. I had 48 hours to prove my innocence. But first, I needed to understand who was really behind Alpine Legal Services. The Delaware corporate filing listed a single officer, Ethan Montgomery. The Delaware filing was time-stamped 3 months ago. Ethan had been planning this operation since before I'd even noticed the first billing discrepancy. I printed the corporate documents and walked to his office. He was reviewing discovery materials, yellow highlighter moving across depositions in steady strokes. "We need to talk." He looked up. "About what?" I placed the Alpine Legal Services filing on his desk. "About this." His expression didn't change. No surprise, no denial, just a slow nod as he set down the highlighter. "How long have you known?" "Since yesterday." The access logs were the final piece. Ethan leaned back in his chair. "You always were thorough. That's what made you the perfect target." "Target for what?" Someone had to take responsibility for the missing funds, the altered billing records, the client complaints. He gestured at the filing. I needed time to establish the offshore accounts, to transfer the money safely. "How much?" $840,000. Spread across 17 client accounts over 6 months. The number hit like a physical blow. Nearly $1 million stolen from people who trusted us with their legal matters. Families going through divorces. Small businesses fighting contract disputes. Personal injury victims waiting for settlements. The partnership meeting on Thursday? I was going to present evidence of your embezzlement. The forged memos, the suspicious billing patterns, your access to the client accounts. He smiled. They would have voted to terminate you immediately, probably filed a bar complaint within the week, while you disappeared with the money. While I relocated to a jurisdiction without extradition treaties, the Cayman Islands have excellent banking privacy laws. I activated the recording app on my phone. You're confessing to embezzlement, wire fraud, conspiracy. I'm explaining a business decision to a colleague who won't be around to testify about it. The threat was clear, but Ethan had made one crucial mistake. He'd assumed I was working alone. Serafina appeared in the doorway. The FBI is here. They're asking for both of you. Ethan's composure cracked. FBI? I contacted the High-Value Legal Fraud Investigation Bureau this morning, provided them with the access logs, the forged documents, and the Alpine Legal Services filing. I stood up. They've been monitoring your communications for the past 6 hours. 2 agents entered the office. The lead agent showed his credentials. Ethan Montgomery, you're under arrest for wire fraud, money laundering, and conspiracy to commit embezzlement. As they read him his rights, Ethan looked at me with something approaching respect. You moved faster than I expected. I learned from the best. The next 3 hours were a blur of interviews, evidence collection, and damage assessment. Law Practice Revenue Review Officer Aaron Russell arrived to coordinate the financial investigation. He was methodical, professional, and deeply concerned about the scope of the fraud. We'll need to freeze all client accounts pending a complete audit, he explained. This could take weeks to unravel. What about the clients? Some of them need immediate access to their funds. We'll prioritize cases involving urgent medical expenses or housing payments, but the majority will have to wait until we can verify which transactions were legitimate. The partnership held an emergency meeting that afternoon. I presented the evidence systematically, the access logs, the forged documents, the Alpine Legal Services connection, Ethan's recorded confession. Senior partner Serafina Blackwood listened without interruption. When I finished, she was quiet for a long moment. How did we miss this? He was careful. The amounts were small enough to avoid automatic flagging. He spread the thefts across multiple accounts. And he was building a case against me to deflect suspicion. What's our exposure? Financial? We'll need to reimburse the stolen funds. Legal? Probably multiple malpractice suits. Regulatory? The state bar will investigate our oversight procedures. And reputational? That was the question I'd been dreading. Significant. This will be public record. Our clients will question whether their money is safe with us. The firm's insurance covered most of the financial losses, but the damage to our reputation was harder to quantify. 3 clients terminated their retainer agreements within the first week. 2 more demanded detailed accounting of their funds. I spent the following month rebuilding trust, client by client, case by case, explaining what had happened, showing them the new security measures we'd implemented, demonstrating that their interests remained our priority. The Bar Association opened a formal investigation into our firm's financial controls. I testified for 6 hours about our oversight procedures, our client account management, and the warning signs we'd missed. Did you suspect Mr. Montgomery was stealing client funds? Not initially. I noticed billing discrepancies, but I attributed them to software errors or administrative mistakes. When did you realize the scope of the fraud? When I discovered the forged memos. That's when I understood someone was deliberately trying to frame me for embezzlement. What changes has your firm implemented to prevent similar incidents? Mandatory 2-factor authentication for all financial systems. Quarterly audits of client accounts. Separation of duties for fund transfers. And enhanced monitoring of document access patterns. Ethan pled guilty to federal fraud charges 3 months later. The prosecution recommended a sentence of 7 years in federal prison and full restitution to the affected clients. His law license was suspended, pending disbarment proceedings. I attended the sentencing hearing, partly for closure, partly to represent the clients he'd victimized. The judge was thorough in her condemnation. "You violated the most fundamental trust of the legal profession. Your clients relied on you to protect their interests, and you stole from them instead." Ethan showed no emotion as she pronounced the sentence: 7 years in federal prison, full restitution of $840,000, permanent disbarment from practicing law. As the marshals led him away, he looked back at me once. I couldn't read his expression. Regret? Anger? Resignation? It didn't matter anymore. The firm survived. Barely. We lost 6 clients and 2 junior associates. But we rebuilt our reputation through consistent, ethical practice, through transparency about what had happened and what we'd learned. I helped other firms implement similar security measures, spoke at Bar Association conferences about financial fraud prevention, shared our experience so others could avoid the same mistakes. The betrayal had cost us nearly $1 million and months of uncertainty, but it had also taught us the value of vigilance, of questioning assumptions, of protecting the trust our clients placed in us. Justice had been served, but the real work was just beginning. 6 months later, I stood in my new office overlooking the Denver skyline. The move from Boulder had been necessary. Too many memories. Too many questions from colleagues who still wondered how I'd missed the signs. The University of Colorado Law School had offered me a position as clinical professor of legal ethics. Teaching felt right. Sharing hard-earned lessons with students who still believed in the nobility of the profession. My first semester course load included professional responsibility and a new offering I'd developed. I created an elective on law firm governance failure case studies. The enrollment exceeded expectations. Apparently, other attorneys recognized the need for practical fraud prevention education. The students were eager to understand how trusted colleagues could betray their partners, how sophisticated schemes could operate undetected for months, how technology could be weaponized against the very systems designed to protect clients. I used our case as the primary example. Names changed, of course, but the lessons remained intact. The importance of segregated financial controls, the danger of unchecked access to client accounts, the necessity of regular audits and verification procedures. Serafina Montgomery had joined me as a guest lecturer. Her forensic accounting expertise provided crucial context for understanding financial manipulation techniques. The students appreciated her practical approach to identifying red flags in billing patterns and fund transfers. The High Value Legal Fraud Investigation Bureau had published our case study in their quarterly bulletin. Aaron Russell had written the summary, emphasizing the collaborative investigation process that had exposed Ethan's scheme. Other firms were implementing similar monitoring protocols. My evenings were quieter now. No emergency client calls, no partner meetings that stretched past midnight, no constant anxiety about hidden threats within our own walls. I'd started running again. The mountain trails near campus provided perspective that downtown Boulder had never offered. The physical exertion helped process the emotional residue of betrayal and recovery. The legal community had been surprisingly supportive. Referrals came from former competitors who respected how we'd handled the crisis. Transparency had rebuilt trust more effectively than any marketing campaign. My new colleagues understood the value of experience earned through adversity. They'd recruited me specifically because I'd navigated a major firm crisis and emerged with enhanced expertise in fraud prevention and crisis management. The teaching schedule allowed time for consulting work. Small firms sought guidance on implementing financial controls. Bar associations requested presentations on identifying internal threats. Insurance companies wanted risk assessment protocols. Each engagement reinforced the same fundamental truth. Trust must be verified through systems, not assumptions. Professional relationships require structural safeguards, not just personal confidence. The students reminded me why I'd chosen law originally. Their enthusiasm for justice, their belief in ethical practice, their commitment to serving clients with integrity. Some had heard about the Boulder case through legal news coverage. They asked direct questions about betrayal and recovery, about maintaining faith in colleagues while protecting against exploitation. I answered honestly. Trust was essential, but insufficient. Verification was mandatory. Systems mattered more than personalities. The semester was ending soon. Final exams approached. Students were preparing for summer internships at firms across Colorado and beyond. I'd written recommendation letters emphasizing character alongside academic achievement. The profession needed attorneys who understood both the nobility and the vulnerability of legal practice. My office phone rarely rang after hours anymore. The constant urgency of private practice had been replaced by the measured rhythm of academic life. Preparation, teaching, research, reflection. The mountain view reminded me daily that perspective required distance. The crisis that had consumed months of my life now served as teaching material for the next generation of attorneys. Evening walks through campus provided the peace that had eluded me during the investigation and recovery. Students passed by, discussing cases and concepts with the intensity I remembered from my own law school years. The betrayal had ended my partnership with Ethan Montgomery, but it had begun something more valuable, a career dedicated to preventing similar violations of trust, a mission to strengthen the profession's ethical foundation. The silence of my new life felt different from the anxious quiet that had preceded discovery of the fraud. This was earned tranquility, the peace that followed justice served and lessons learned. It was finally over, and the silence felt earned.